Welcome to the Supreme Court of the United Kingdom. Today we are hearing the second day of an appeal in the case of KE Entertainments and Her Majesty's Revenue and Customs. The case is concerned with the law governing VAT, and details of it can be found on our website by clicking on the link to current cases. I'm Lord Reid, and I'm hearing the appeal together with my colleagues Lord Hodge, Lord Lloyd-Jones, Lord Sales, and Lord Leggett. At present, we are hearing submissions from Mr. David Thompson, Queen's Counsel, on behalf of the Crown. And after he has completed his submissions, we will hear a reply on behalf of Mr. Roderick Ordara, Queen's Counsel, on behalf of the taxpayer KE Entertainment. Mr. Thompson.
I'm obliged, my Lord. Having had the benefit of yesterday's discussion, my Lords, and the opportunity to reflect on matters overnight, there are three remaining matters which I wish to address in submission this morning. They are, first, the proper approach to apportionment for the purpose of identifying the taxable consideration in gaming transactions. Secondly, the legal status and practical effect of the business brief, including a very brief response to the taxpayer's apparent reliance on the doctrine of legitimate expectation. And thirdly, submission concerning the proper scope of Article 90 and Regulation 38. Lords, I aim to take these points as quickly as possible, well within the 1 hour which I think I have available to me this morning. Turning to the first of these matters, then the proper approach to apportionment for the purposes of identifying taxable consideration. I have already submitted to the court that this exercise, the Article 73 exercise, is not the same as the Article 90 Regulation 38 exercise. Proper understanding of the Article 73 apportionment exercise, however, does allow one in my submission to identify what is actually required in order to give rise to an Article 90 price reduction after the supply has been made. Fundamentally, the Article 73 exercise in gaming transactions, as with most other aspects of the VAT system, places considerable emphasis upon commercial and economic reality. There are two passages in the cases to which I would draw the court's attention in that respect. First of all, in the Glauspiel case, from the judgment, or the opinion rather, of the Advocate General Sir Francis Jacobs, that's at page 735 in the electronic bundle, paragraph 18. So page 735, paragraph 18, rejecting the argument which had been advanced on behalf of the German government in that case, that the taxable amount was the whole sum paid by the taxpayer. The Advocate General explained that that approach was inconsistent with the commercial reality of the transaction and with the aims and basic principles of the directive, and that because VAT is intended to be charged in proportion to the actual turnover which a trader earns from his supplies. In that case, as the Advocate General explained, for all practical purposes, the operator's turnover consists in the amount he is able to remove from the machine, not the total amounts inserted by players. That passage of the Advocate General's opinion, my Lords, was given effect to by the court at paragraph 9, its judgment, which is at page 739, the electronic bundle. The second passage I wanted to refer to also comes from another opinion of Sir Francis Jacobs, the Advocate General, in the Fisher case. That's to be found at page 771 of the electronic bundle. And it's paragraph 45 of his opinion towards the foot of that page. And the court will see that after referring to the judgment of the court in Glauspiel, 5 lines in, the Advocate General states it is ultimately only the amount retained by the organiser after payment of winnings which is available to cover his profit margin, the costs of running the gambling establishment, VAT and other taxes which may be payable on his activities. It is that amount which may therefore be equated with the manufacturer's VAT inclusive turnover. By calculating the tax by reference to that amount, the tax remains exactly proportional to the organiser's turnover. And I think I mentioned yesterday that that's the essential underpinning of the approach that one sees in these cases, that it's the amount that the operator can retain which falls to be regarded as equivalent to a turnover in normal supply cases. As my learned friend submitted yesterday, that passage or that part of the Advocate General's opinion did not require to be addressed by the court because the court decided that the unlawful gaming transaction in that case was exempt and thus it didn't discuss the apportionment issue. Domestically, Article 73, as we know, is given effect to by Section 19, subsection 4 of the 1994 Act. As I have understood the argument for the taxpayer, it is that it is further the duty of the United Kingdom state actually to fix the taxable amount, or at least actually to fix the methodology for its calculation. And if I can give the court simply the reference at this stage to that part of the argument, it's paragraph 91 of the taxpayer's written case, which is at page 140 of the electronic bundle. And towards the end of the taxpayer's written case, the same point is made in its conclusions at paragraph 118, page 151 of the electronic bundle. Now, so far as this argument is concerned that it's the duty of the UK to fix the formula or methodology, it's worth drawing to the court's attention that before the Inner House, it was the contention of the taxpayer that Section 19, subsection 4 was a power that conferred on the Commissioner the ability to fix the appropriate methodology. So specifically, Section 19, subsection 4 was said so to empower the Commissioners, and it was by that means the UK was said to have discharged this obligation, according to the taxpayer, to fix the formula. Before this court, the argument rather seems to be that it's the care and management powers of the Commissioners that empower the Commissioners to fix formula. In my submission, my Lords, while it is plainly correct that the UK, via its tribunals and courts, must give effect to the directly effective rights which arise under Articles 73 and 90, including in respect of the former article, the determination of a proper attribution to allow the taxable amount to be calculated. That is the extent, in my submission, of the involvement of the UK state. Parliament has legislated in Section 19, consistently with Article 73, for a method of apportionment, and that then in any given case falls to be given effect to. Thus, by contrast, Lords, in my submission, there is no warrant in the directives, the jurisprudence, or the United Kingdom legislation for the view that it's the UK state, and specifically the Commissioner, who are obliged to prescribe a particular method of apportionment. All of that, Lords, in my submission, when we step back from the specific context of Section 19, subsection 4, all of that is consistent with the basic nature of value-added tax as a self-assessed tax. The basic duty, of course, is on taxpayers to calculate the tax due, to prepare returns and to submit them, and to account to the Commissioners for the tax so due. There are two dicta of high authority which I just wish to give to the court by way of reference in this respect. The first is from the speech of Lord Keith Kinkell in Fine Art Developments and Commissioners. That case is at tab 46 of the bundle of authorities. And the passage I refer to, my Lords, is to be found electronic page 1031, which is page 897 of the report. So page 1031, and it's between letters B and C, top of the page, 5 lines into that paragraph, my lord should see the sentence beginning, VAT is a self-assessed tax, and the responsibilities of the traders are set out, including, with reference to subsections 3 and 4 of the then section 10 of the 1983 Act, the equivalent exercise under section 19, subsection 4. So these are the responsibilities of taxpayer, VAT being a self-assessed tax. A similar statement, my lords, is to be found in the judgment of Lord, the speech rather of Lord Walker in the case of Lex, which is at tab 50 of the bundle, page 1092 in the electronic bundle, and it's paragraph 18. And about 7 or 8 lines into paragraph 18, lords, towards the right-hand side, should see a sentence beginning, it, that's the VAT system, is a system which is intended to be self-policing in the sense of operating automatically on the economic activities of registered taxpayers and final consumers with the least possible need for VAT authorities to undertake independent investigation of the fact, consistently with the idea that one is dealing here with a self-assessed tax. So in general terms, my lords, in my submission, the VAT system falls to be seen in that way, self-assessment system with the onus on the taxpayer to prepare returns, calculate the amounts due, including in respect of apportionments, submit the returns, as well as paying any output tax due to the Commissioner. And against that general background in my submission, that is consistent with the submission I've advanced that there is nothing in Article 73 or Section 19 of the Act, or indeed in the Commissioner's care and management powers, which support the taxpayer's contention that it was for the UK state commissioners to fix a definite method of apportionment. Indeed, finally, on this particular point, my lords, it seems in my submission to run somewhat counter to other aspects of the taxpayer's argument, this suggestion that it was for the UK state to fix the method. For example, at paragraph 56 of the taxpayer's case, page 126, electronically, it is stated that the Glauspiel line of authority gives almost no guidance as to the way to construct the deemed answer on apportionment. This may simply be because it is an intensely factual question and not one of law at all. In my submission, lords, therefore, by adopting a method of apportionment which is identified in guidance issued by the Commissioners, such as the business brief in this case, Lord Tarr was correct to put it as he did at paragraph 79 of his opinion, page 246 electronically, that where a taxpayer follows guidance issued by the Commissioners, the taxpayer has the reassurance of knowing if he chooses to follow that guidance, his self-assessment is unlikely to be challenged by the Commissioner. And indeed, in any given case, if the Commissioners were to seek to go back on guidance which had created a legitimate expectation, creating unfairness for a taxpayer who had placed reliance on it, public law remedies may arise in relation to legitimate expectation, at least as a matter of principle. On the other hand, in the event of disagreement between the taxpayer and Commissioners, as was recognised by the First Division, that situation, the appropriateness of the apportionment against the background of any guidance given by the Commissioners, it would simply fall to be determined by the court in the normal way. And that, should say, my lords, is recognised and applied by Lord Justice Lewison in the case of Leeds and the Commissioners, page 1370 of the electronic bundle, paragraph 43. So page 1370, paragraph 43. Now, my lords, this issue about the effect of the business brief leads me on to that particular issue, the status of the business brief properly understood. The taxpayer, my lords, in my submission appears to misapprehend the Commissioner's position regarding this matter. There are various references with the taxpayer's written case to the suggestion that the business briefs fall to be regarded as nullity or having no effect whatsoever. To recapitulate, it is the position of the Commissioners, and it is my submission, that business briefs did not have the force of law in the sense they did not amount to the intimation of a legal requirement which the Commissioners were empowered to issue. Rather, they simply represented the Commissioner's opinion as to the proper application of the law in the particular case of the calculation of the taxable amount in supplies of bingo. They were, however, lawfully issued in the sense that they were within the power of the Commissioners to issue guidance of that sort. That understanding of the business briefs, my lords, is again well supported by authority, and if I could simply give my lords two references in respect. First of all, in Fleming itself, tab 50 in the authorities, page 1108, from the speech of Lord Scott, paragraph 20, just around letter H, the Lords will see a passage beginning, the VAT regime is not judge-made and is not made by the Commissioners. And in the remainder of that paragraph, Lord Scott explains, consistently with the submissions I've just made, the proper status and understanding of business briefs issued by the Commissioners. For completeness, I should mention to my Lords that that passage...
Forgive me, I'm sorry to interrupt. Mr. Thompson, I'm having some difficulty in hearing you. It's probably my fault. But could you just give that reference again, please? The name of the case? I thought you said was
Fleming.
1180.
So it's the case of Fleming trading as Bodycraft against the Commissioners.
Thank you.
And the page to which I've been referring, my lord, is page 1108.
And 8, thank you.
It's 1108, paragraph 20, letter H.
Thank you.
And from the speech of Lord Scott, and I was just going to mention, this passage is referred to at paragraph 6.8 of the written case for the Commissioners. Just so the court is aware, it is wrongly attributed there to Lord Newberger. It's actually from the speech of Lord Scott, as I've just mentioned. The second passage to make good this proposition, to which I draw the court's attention, is from the case of Leeds and the Commissioners. And if I can just give the court the reference, it's page 1360, paragraph 4, from the judgment of Lord Justice Lewison, where he again explains the status of guidance of this sort issued by the Commissioners. And finally, if I could mention to my lords that in the opinion of the Lord President, at paragraph 20, page 207 of the electronic bundle, his lordship refers to certain other authority that made that proposition, including certain passages from Devoyle. So that was page 207 electronically, paragraph 20 of the opinion of the Lord President. So, my lords, in my submission, it follows from all of this that it is not correct to say, and it is not the Commissioner's case, that the business briefs fall to be treated as a nullity. Rather, the Commissioner's submission is that these simply fall to be regarded as the representation of the lawful expression of opinion by the Commissioners as to the proper approach to take in relation to apportionment. Having set the scene in relation to the status of the business briefs generally, I wanted to look in a little more detail at business brief 0707. I can take this quickly because it's been before the court already, and I indeed have made certain submissions about it during the course of yesterday. If my lords could turn up, please, page 452 within the electronic bundle. This is the second page of business brief 0707. And we saw the heading, Making Claims or Adjustments. This is the section of the document, my lords, as I understand it, which the taxpayer contends or contended in the tribunals below and the court below had effect of requiring to go back and revisit all previous returns. And that indeed, for completeness, my lords, is the basis on which the taxpayer set off in the present appeal before this court. If the court could take note, please, of paragraph 10 of the narrative of facts given by the taxpayer in this case, which is at electronic page 14 in the bundle, paragraph 10, page 14. It is unequivocally stated there that the taxpayer's position is it was required to undertake the recalculation going back to 1996. In his submissions yesterday, however, my learned friend put the matter somewhat differently. He instead characterised the business briefs as being some kind of offer by the state having legal effect, which the taxpayer accepted. He didn't lay emphasis on it being a requirement with which the taxpayer had to comply. Now, in relation to that analysis, that this was a formal offer having legal effect, that's somewhat odd in my submission, Lords, not least given that if that is the proper understanding, contrary to my submissions of the business brief, the taxpayer appears to have accepted that offer by submitting a Section 80 claim in respect of the Fleming period. The court doesn't have all the details of the Fleming claim. I can give the court two references to it. First of all, paragraph 20 of the judgment of the first tier tribunal, which is at electronic page 283. It's confirmed that the taxpayer submitted a Fleming claim, and that is reaffirmed at paragraph 13 of the statement of facts and issues before this court, electronic page 102. So in other words, shortly after the business brief was issued in 2007, the taxpayer made a claim under Section 80 for the Fleming period, which took it back to 2004. And it was only in January of 2013, following the issuing of the judgment of the first tier tribunal in Carlton Clubs, that it sought to, by way of its December 2012 tax return, undertake this putative Regulation 38 exercise going back to 1996. So the court has the reference. That claim was submitted by letter from the accountants for the taxpayer dated the 29th of January 2013. That letter and the corresponding claim may be found at electronic page 381 within the appendix. Now, my lords, so far as the business brief 0707 itself is concerned, it's already been identified, I hope, for the court in submission yesterday, that this was a document that was issued to the bingo industry as a whole, and it was issued in response to queries that had been received by traders in that industry. Critically, looking at page 452 of the document, the court should note on the second line, it refers to taxpayers who find that they have done so incorrectly. In other words, that they have accounted for tax incorrectly on the game basis. And on the third line, that is said to result in an over-declaration. And as the court will appreciate in my submission, reduction in consideration after the supply has been made does not result in any return having been incorrect, and nor would it give rise to any over-declaration. Similarly, the reference to unjust enrichment, which appears just after the two bullet points, for the reasons I touched upon yesterday, is only explicable with reference to Section 80 claims. What I wanted just to fill in the gap, as it were, is in relation to the two bullet points which appear between those two passages. This is the discussion about if the errors, and again, of course, errors are only consistent with the over-declaration of tax, not with a post-supply reduction in consideration. The reference to errors not exceeding £2,000 being addressed by way of adjustments in a current VAT return. So the court is aware there is a statutory basis for that position. First of all, Section 80 of the Act, as it stood at the time this business brief was issued, may be found at page 585 of the bundle. So 585. And if the court goes to subsection 6 on page 585, my lords will see that it is there provided a claim under this section shall be made in such form and manner and shall be supported by such documentary evidence as the commissioners prescribe by regulations, and regulations under this subsection may make different provision for different cases. Of course, first of all, it's worth noting there, see an example of Parliament conferring legislative power on the commissioners. That's exactly the type of language that is used when the commissioners are being empowered to make law rather than simply apply the law, in contrast to section 19, subsection 4. But subsection 6, having provided for regulations to be enacted, if my lords go to page 1800, which is in the, this was in the one of the bundles that was passed to the court more recently, and it was the supplementary authorities 83 and 84. The court turns up within 83, page 1800. This is regulation 34 of the 1995 regulations. Yes, I think Lord Lloyd Jones.
Yes, I'm working off the supplementary bundle, which has separate pagination. What page is it in there?
It's page 11, I think.
Thank you very much.
I'm obliged to Lord Reid. So
Okay,
section,
thank you.
regulation 34 rather, Lords will see that it applies per regulation 34.1, where a taxable person has made a return or returns to the controller which overstated or understated liability to VAT, and it's subparagraph 3 of regulation 34, which if Lords follow it through, we'll see it makes reference to the position where the under declaration or over declaration does not exceed £2,000. The taxpayer may correct it in accordance with the regulation. In other words, through his VAT return. So that's the statutory basis for this part of the business brief that refers to the £2,000 figure. Finally, Lords, in relation to the publications issued by HMRC, will be recalled that business brief 0707 referred in turn to the document 700/45, which is in page 1745 of the electronic bundle.
We have this in a separate bundle.
I'm obliged, my lord. So it's that document 700/45, and there are just a couple of points I wanted to highlight from that.
I'm very sorry. I'm having difficulty in hearing. I'm not hearing the references. Sorry.
I'm sorry, my lord. So it's the HMRC publication notice 700/45. 700/45.
And where is that found, please, Mr. Thompson?
Page 1745. I think from what Lord Reid said a moment ago, it may be in a separate bundle.
Yes, this is a document that was sent to us by email last Friday, and we now have it in our SharePoint bundle as a separate item.
Yeah, could you bear with me for a moment then, please, while I find that? Yes, thank you very much. Got it.
I'm obliged, my lord. So, if I could ask my lords to turn, first of all, to sections 4.2 and 4.3.
If you have, Mr. Thompson, at the foot of the page, you'll see it's page X of 42. Well, that's in fact our numbering. So if you're able to give us the page.
Page 5 of 42 on that.
Thank you.
So what we see, my lords, there at paragraphs or sections 4.2 and 4.3 is the way that one is to, according to the guidance from the commissioners, correct errors, which is a section 80 process, as we've seen. And again, the provisions in the 1995 regulations about this £2,000 threshold, which we've considered already, is there identified. So that's about the correction of errors. If one turns then to page 7 of 42 within that bundle, section 4.8, my lord should see the heading is, what about adjustments that aren't errors? And that paragraph begins stating, adjustments that you are required to make as part of normal operation of VAT accounting aren't errors. These include, and the final bullet point on that page is, issuing or receiving credit and debit notes. And that process, and you'll see it says see section 9. Section 9 begins on page 16 of 42. And that's the whole process to do with Regulation 38 credit notes and the like. So, yes, it is correct that Business Brief 0707 refers to this document, 700/45, which in turn addresses Section 80 claims as well as other things. If one reads the two documents together in the way that I have sought to demonstrate to the court, in my submission, it's quite clear that the parts of this document, 700/45, that the Business Brief is referring to is the correction of error section and not the making of adjustments pursuant to Regulation 38. So, my lords, and for those reasons, it's my submission that once one actually looks at the terms of the event, which in the analysis of the taxpayer is said to have given rise to its entitlement or its obligation to recalculate the apportionment under Regulation 38, in my submission, it is quite clear that the Business Brief 07, which as I've submitted was simply the opinion of the commissioners, on no tenable construction of its terms actually had that effect. It was plainly in my submission countenancing the position of taxpayers who had accounted for tax which was not due, in other words, a Section 80 claim. In that connection, and before leaving this issue of the Business Brief and the effects of it, I wanted just to mention very briefly the tentative suggestion in the taxpayer's case that some kind of legitimate expectation arose from the previous guidance issued by the commissioners. My lords, in my submission, that argument simply does not get off the ground, notwithstanding the fact that the commissioners take no issue with the analysis of the principles of domestic law in relation to legitimate expectation that are offered by the Court of Appeal in Auzora, the authority to which my learned friend referred yesterday. There are 5 short reasons in my submission why a case based on legitimate expectation could not work in the present case. They are: first, legitimate expectation is engaged where a representation has been made and that expectation falls to be protected against some subsequent detrimental change in position. Secondly, it follows from that in the present case, the commissioners have not sought to undo, far less prejudicially, any reliance placed by taxpayers upon the earlier business briefs. Rather, they have simply stated an opinion as to how prospectively taxpayers should calculate a taxable amount, and they have indicated the potential in principle for taxpayers who have over-declared tax to make a claim under Section 80. Thirdly, in order for there to be a legitimate expectation capable of protection, it would have to be established that it would be unfair to allow the public authority, in this case the commissioners, to depart from its previously stated position. And it follows from that, fourthly, that in the present case, There is not, and nor could there be, any unfairness in the Commissioner's publication of an updated opinion which improves the position of taxpayers. In this connection, Lords, it is unsurprising to note that there are no findings in fact made by the first-tier tribunal which could possibly support an argument based upon legitimate expectation and unfairness. And indeed, there is nothing in the taxpayer's written case that actually identifies what the unfairness to the taxpayer might possibly be. The fifth and final point, Lords, is this, that the concept of legitimate expectation in any event could only have application in the field of public law remedies, rising most obviously by way of judicial review, for example, seeking remedies to prevent the Commissioner departing from the terms of the previous business briefs. And in my submission, public law remedies of that sort are not available in tax appeals of this sort. And for completeness, that proposition has recently been affirmed by the Court of Appeal in a case which I regret is not in the bundle before the court, but I can make it available via those instructing me. So the court has the reference. It's the case of Metropolitan Schools Limited and the Commissioners, 2019 1 Law Reports, page 5473, paragraph 20. And as I've indicated, Lords, I can make a copy of that case available to the court via those instructing me. So for all of those reasons, Lords, my submission is that the business brief simply did not and could not have the effect intended for by the taxpayer. And the change of opinion that was expressed in Business Brief 0707 likewise did not alter the position. Finally then, Lords, I want to turn to the proper application of Regulation 38. I've submitted in that connection already that the cases founded upon by the taxpayer are actually all concerned with Article 11A or 73, not Article 90. When one looks at the authorities which actually arise under Article 90, in my submission, they do establish the proposition that there has to be some, as it could be put, real world change in the amount actually received or retained by the taxpayer after the supply has been made. And I want to just look very briefly at one or two passages in the authorities in that connection. Firstly, in the case of Goldsmiths and the Commissioners, at electronic page 780, that case begins, and if I could ask my Lords to turn specifically to page 793, paragraphs 15 and 16. And at paragraph 15, towards the foot of the page on page 793, my Lords will see discussing Article 11A, which is what has been discussed in the immediately preceding paragraph. The court continues, that provision embodies one of the fundamental principles of the Sixth Directive, according to which the basis of assessment is the consideration actually received. So that's what the Article 73 consideration is about, the amount actually received. And it's the other side of that coin in paragraph 16, that Article 11C, now Article 90, is concerned with situations where member states are required to ensure that the taxable amount is reduced accordingly under conditions to be determined by the member states. And that provision requires member states to reduce the taxable amount, consequently the amount of VAT, where after a transaction has been concluded, part or all of the consideration has not been received. So that's part or all of the consideration actually received has in fact no longer been received or has had to be returned, something of that sort. The emphasis is upon the commercial and economic reality with reference to what has actually been received. I want to give the court two references before turning to one case I want to look at in slightly more detail. The two references that are to the same effect from the Court of Justice, Lords, are in Freeman's, paragraphs 28 to 36. So Freeman's paragraphs 28 to 36 are to be found in the bundle at pages 855 to 856. And secondly, in the Kraft Foods case, paragraph 26, which is to be found at electronic page 963. Those passages from the Court of Justice are consistent with the approach set out in Goldsmiths, to which I've referred. The case I wanted to look at in slightly more detail, my lords, is inventive tax strategies. That is to be found at page 1399 of the bundle. So page 1399, this was a case that came before the upper tribunal composed of Mr. Justice Mann and Judge Richards. And if I could look first of all at the rubric of the case, on the first page just above letter E, the Lords will see that in this case, the appellant taxpayers carried on tax consultancy businesses which involved the selling of tax avoidance schemes with a particular emphasis on stamp duty, land tax. In providing their advice in relation to such schemes, the appellants were making taxable supplies of services for value-added tax purposes. They sold their avoidance schemes in return for a fee on which VAT was charged at the standard rate, and account was made to the commissioners in the normal way. Importantly, however, what we then see is this: the terms on which the appellant sold the schemes included an undertaking to refund the fees to customers if the underlying scheme was unsuccessful. Facing the prospect of having to make significant refunds, the appellants either went into liquidation or administration because the schemes had been unsuccessful, and they issued credit notes to the customers as evidence of each customer's entitlement of a refund of the fee charged for the avoidance schemes. However, no amount was ever actually paid to customers. It nevertheless argued for the taxpayers via their liquidators that there had been a decrease in consideration for the purposes of Regulation 38. In other words, the credit note, taken together with the contractual obligation to give a refund, was argued by the taxpayer as engaging in Regulation 38. So those being the facts, if I could ask my lords to turn first of all to page 1406, paragraphs 20 and 21, I just want to give the court that reference, that under the heading economic reality, the judgment of the upper tribunal addresses this, the importance that inheres in proper attention being paid to considerations of economic reality in the application of the value-added tax system, commercial and economic reality, which I have been seeking to emphasize in my submission. The case of Elida Gibbs is considered by the upper tribunal at paragraphs 34 to 35 on page 1410, concluding paragraph 36. And I commend to this court the comment and observations of the upper tribunal about Elida Gibbs, and in particular the conclusion at paragraph 36, or halfway through paragraph 35 rather, that Elida Gibbs is not concerned with the distinction between contractual rights and actual payments, and is fundamentally not concerned with Article 90. It's not concerned with informing us as to the proper approach to be taken to the application of Article 90. That's the way it's put, my lords, on the second final sentence in paragraph 36. Elida Gibbs sheds little light on the distinction, if any, between contractual obligations and actual payments for the purposes of Article 90. And for that reason, and the reasons I've touched upon in submission already, my submission is that the weight should be, the court should give on the authorities is to those cases which I found upon in relation to Article 90, and not the approach contended for by the taxpayer in relation to Elida Gibbs. So far as the critical question of whether Regulation 38 and Article 90 were engaged on the facts of inventive tax strategies. The upper tribunal's consideration of that issue begins at paragraph 56 at page 1414 of the bundle. And that discussion, my lords, carries through to paragraph 67. I draw attention to paragraph 58, where the upper tribunal, so this is at the foot of page 1414, paragraph 58, the tribunal refers back to considerations of economic and commercial reality, and indeed refers to the case of Grattan from the Court of Justice, which I have commended to the court already in the course of my submissions. In the particular circumstances of for the upper tribunal, my lords will see at paragraph 61 on page 1415, the upper tribunal stated that the commercial reality is that there neither has been nor will there be any refund of price, or at least that it cannot presently be demonstrated that there will be any such refund. We consider that that means there is no reduction in price for the purposes of Article 90. The purported reduction is just a paper one in circumstances with no commercial substance. That means that no adjustment falls to be made under Article 90. My submission is that is correct, and it's the approach I commend to this court in the present appeal. The remainder of the reasoning down to paragraph 67 in the judgment of the upper tribunal, I likewise commend to the court as being the correct approach to Article 90 and Regulation 38. Before leaving the authorities, I wonder if I could simply give to my lords, first of all, the reference that's in, or emphasise the reference that's in the Commissioner's case at paragraph 715, the case of Iveco, the judgment of Lord Justice Newey from paragraph 44 onwards, which begins at page 1260 to 1261 in the electronic bundle. And in that connection, my lords, thinking about the approach the upper tribunal took to the mere paper exercise in inventive tax strategies, I could mention also paragraph 48 of the judgment of Lord Justice Newey and Iveco at page 1261, where his lordship observed, "I do not see why a supplier's entitlement to rely on Article 11C against the United Kingdom should permit him to reduce the taxable amount himself and so trigger a repayment claim years later." And that is precisely the legislative context is different in the present case, given the history of delayed implementation in Iveco. But the force of the point in my submission is the same, that the taxpayer in this case, purely at its own hand, undertaking a mere paper exercise with no commercial reality, seeks to allow itself years later this significant reduction in the taxable amount. In my submission, that is not permissible. So to conclude in relation to matters and draw it together, my submission is that it's clear that Article 90 and Regulation 38 do require a real-world reduction in respect of the monies in the hands of the supplier before the taxable amount may be taken to be reduced. On the facts of this case, there has been no such real-world reduction, and consequently there is no entitlement inherent in the taxpayer to reduce the consideration. To the extent that the taxpayer argues that to require it to demonstrate a real-world reduction in consideration and the concomitant requirements regarding the issuing of a credit note to its customers make it impossible for it to secure its Article 90 rights, in my submission is to overlook the essential point I made yesterday, that the truth is it is simply the case that the nature of the supplies made by this taxpayer are such that it's very difficult to see circumstances in which Article 90 would ever be likely to be engaged.
Thank you very much, Mr. Thompson. Mr. Kodara.
My lords, in reply, may I take as a first heading the question which has somewhat emerged in the course of debate yesterday as to whether this might not be a case in which there is a single lawful answer. Because obviously, if it is such a case, then it would be possible for Section 80 to be engaged. If, on the other hand, there is more than one lawful answer, then Section 80 would not, in our submission, be engaged, unless, of course, the answer proposed is not within the spectrum of reasonable or possible lawful answer. If that matter can be dealt with in the manner in which we submit it should be, then it does become very plain that this is a question of apportionment, in respect of which there can be more than one lawful answer, and therefore the examination of the terms, particularly of the 2007, this brief comes to centre stage. So just dealing quite briefly with this first question, it is agreed between the parties, refer to something my learned friend said earlier today about Section 19.4, that Parliament has indeed legislated for a particular apportionment of the deeming. So we know at parliamentary level, we are apparently this debate in an area of we know in practical terms from the nature of the bingo stroke gaming world that one is, the challenge is to look at the single sum, no discussion, there's no overt agreement of the sort that Lord Walker envisaged in the much quoted passage in Lex. So we know that that has somehow to be divided. Thirdly, we find little or no guidance in the European cases, European field cases, as to how to conduct that, save the phrase over a given period. No guidance is offered there. Fourthly, as your lordships will know, Lord Tyre at paragraph 80 on bundle page 246 acknowledged that this is indeed one of those cases where there may well be more than one right answer. And fifthly, Lord Drummond Young at paragraph 70, page 240, appears to have said the same. I think he might have said no right answer, but implicitly that would have been presumably a reference to more than one right. Sixthly, none of the courts or tribunals below have in fact held that Section 80 apply here in the shape of a conclusion that for reasons X, Y, and Z, the game-based approach to the apportionment is on its face wrongful and outside the lawful area created by the Glagspiel cases. And we don't detect any, well, there is obviously no cross appeal, but we can't at the moment envisage that it is indeed open. If the Crown is in fact contending this, and mindful of the debate between the court and my learned friend yesterday, which I won't try to summarize, but there is no scope in terms of the shape of proceedings for the issue to come up now. Seventhly, it is an economic judgment, and we say it lies along a spectrum of possibilities. It's therefore very different from many another VAT case where one is looking at the status of a supply, is insurance, is it a biscuit, all those familiar VAT issues, which of course only admit of a single. And then eighthly, turning briefly to the case for the Crown, if I may just remind the court of certain key references. At paragraph 2.3, page 155, the Crown acknowledged that, I won't read it all, quote, there are two ways in which the participation fee can be calculated. And it then refers in neutral terms to both the game and the session basis, making the uncontroversial point at 2.4 that the latter is more favorable to the bingo, point to which I will return shortly. Then at 8.4, page 185 of the bundle, again, if I may say so very properly, the Crown indicates how that fact would fit within Section 80, making the point that any lawful means calculating reconsideration would not result in a payment of tax that was not due. And then importantly, at 8.7 on page 187, having quoted extensively from the Victoria and Albert Museum case, to which I shall, if time permits, return, the Crown says, in drawing conclusions from that, first quote again, page 187, first, there may be more than one acceptable method of apportionment that is consistent with the position adopted by the parties to the application, that apportionment on either the game basis or the session would comply with the requirements of Section 94 VAT Act, where the taxpayer was making participate in both games and session. And then there is 8.12, which your lordships seen, and particularly this is on page 188. The second sentence says, in cases where a taxpayer was making supplies of the right to participate in both games and sessions, apportionment on a game-by-game basis would not have been the sole type of apportionment to comply with the requirements of Section 19.4 of the Act. So, my lords, my eighth point is that it is simply not an issue that there are at least 2 points on the spectrum, game and session respectively, which can yield a lawful and compliant figure. The ninth point, which I've already made, my learned friend has just been dealing with the 2007 note. I may just very shortly respond to his observations of a few moments ago. He refers to the 2007 notice, and it is noteworthy that the Crown did not respond to the central that we make, that notice speaks of correction and or adjustment, and did very properly take your lordships to notice 700/5, but that equally refers both to correction, which is the Section 80 error correction world of regulations 34 and 35, but also to adjustment, which is the world of regulation 38, particularly sub 2, which uses that very word to describe the process. That can be found in the bundle in its contemporaneous version at page 1802. It's up-to-date version, page 5. And one must recall also Regulation 38 sub 7, hope I referred to, which guards the frontier between Regulations 34 and 35, the error correction world, and Regulation 38, the adjustment world, saying that anything that falls within 34 and 35 cannot fall in 38. My lords, the 10th point is that turning from the structure of the issues to the actual question, there is a good reason why the parties are relevant, because it is, we say, very difficult to argue that there is not sufficient internal logic in the game-based approach to put it on the lawful spectrum as one reads it from the Glauber-Spiel case. By internal logic, I mean the game, unlike perhaps the pulling of the lever in the Glauber-Spiel fruit machine, the game is indeed a contest between the participants. It is a unit of gaming. It has the possibility, as your lordships know from state practice issues, of a calculation of stake and participation fee, and it can give an answer. That, therefore, we say, quite apart from the position that I've just outlined in terms of the pleadings, is quite sufficient logically to admit it to the group of possible outcomes. And nor should it be forgotten that where the prizes, say one has a book of 10, were the prizes to be equally in equal amounts spread across the games in equal amounts, mathematically there would be no difference in the outcome between a session-based approach and a game-based. Figures would simply be worked out in 2 stages, but the answer would be the same. That doesn't happen because the prizes towards the end of the session are increased. That, in a practical commercial sense, leads to the advantage my clients, and indeed the disadvantage which the commissioners have identified. But it is only because of the skewing of the prizes that issue arises. That, we submit, doesn't practical reality, done no doubt for commercial reasons, but it doesn't render the game-based approach unlawful. It doesn't place one in Section 80 territory. Just before moving to the next point, or a subset perhaps of this, the test in my submission is, can it be said as a matter of law that a game-based approach is inconsistent with the guidance, such as it is, in the Glauber-Spiel line of, or put another way, can it said, whatever given period might be chosen, the one that can never be right, game-based? We say the answer must be that the game-based period can, and in this case, uncontroversially is, within the spectrum of reasonable outcome. If that.
Observing that it does seem an irony, to put it no higher, that you're strenuously arguing in this case that your clients correctly and properly paid an amount of tax on an appropriate basis. And then somehow to conclude from that entitles them to a much bigger repayment than if they'd actually been overpaying tax. I mean, looking at it from any common sense point of view, it's an absurd proposition, isn't it?
My lord, I was going to point out the not the last part of what my lord said, but the first part. in just a moment. There is no irony if one, as is central to our case, takes on board the very fair points that my learned friend made this morning about it being a self-assessed tax, and the points that I'm about to make in response to what my learned friend said about the status of this guide. On the one hand, your lordships have the commissioner saying it's a mere expression of opinion. At its most extreme, my case is or has been that, and certainly this was accepted by the Carlton Club's tribunal, we've got the commissioners instructing us what. My submission is that, again, perhaps in furious agreement with the commissioner, Victoria and Albert puts us in the right place in the sense that self-assessed tax, the commissioners do not sit on their hands and they do not just leave it to taxpayers to muddle through. Most taxpayers want to do the right thing, and the commissioners give guidance. And this is critical, in the area of apportionment, that guidance has a much heightened level of importance and status. And this is, in fact, this is the Victoria and Albert point, and I will in a second take your lordships to my learned friend's very helpful quotation of Mr. Justice Turner on this point. So I do accept the irony. I respectfully do not accept the absurdity. It goes with the system. But may I backtrack momentarily and just hopefully make the last observation as to whether Section 80 is engaged in this. It comes from my submission, essentially is set out in our case at paragraph 114 A to E. That's on page 148, where we deal with a point that the commissioners haven't in fact made, but might be coming out of dialogue between the court and my learned friend yesterday. And that is the card protection plan point. That is the case where the European Court gave guidance, although, as it said, even that guidance was not exhaustive as to how one disentangles commercial transactions into one or more suppliers. So, my lords, I don't wish to labour this point too much, but as your lordships can see from our case at 114 A to E, we make the point there, page 148, that card protection plan and the case law around that is concerned with what is being supplied. And that only comes up if there's a possibility, your lordships well know this, so I ask forgiveness for repeating it, where there is perhaps a boundary within a transaction between an exempt or taxable supply or a taxable rate. Card protection plan is not a tool of valuation, so that's the first point we make. We make an assertion in D that each game is a supply in its own right. And just 2 points about that. First of all, it doesn't matter, and it didn't matter to the tribunal in this case. At paragraphs 100 to 101, page 300 of the bundle, the tribunal said it could go either way. Page 300 of the bundle, the tribunal said, I quote in part, the activity of playing bingo can be analysed as a single supply for each game, with one consideration paid at the outset, I think that must be of the session. Or alternatively, the activity can be analysed as a single supply of a session of bingo or a single consideration. They go on inconclusively to or to indicate that they don't reach any conclusion. That is indicative, we say correctly, of the fact that whether it's a single supply or not, doesn't affect the Glaber-Spiel approach. And of course, your lordships will know from the Glaber-Spiel cases themselves that the whole point of it is a blending of many, many supplies. For example, in First National Bank of Chicago, sums paid for Forex transactions on a Monday would be aggregated, separated, put into a mix over a long period, without the slightest regard whether there was a single supply of one group of Forex transactions or separate supplies, foreign exchange transactions. In the same vein, the statement of facts and issues at page 97, at paragraph 1, notes that halfway, two-thirds of the way through, that the unitary payment entitles the customer to take part in a number of games of bingo, each of which is a freestanding game with its own winnings. The customer is there to play individual games of bingo. I mentioned that because if your lordships will permit a very brief view of the CPP case, Child Protection Plan case, which is at divider 47, page 1041, divider 47, page 1041. One sees, if one turns to paragraphs, the court, this is one of those cases where the court differed from the ambiguous journal, page 1066, paragraphs 27 to 31, which I won't read. My overall submission is none of this matters, but paragraph 30, at letter just below letter C, the court said this: a service must be regarded as ancillary to a principal service if it doesn't constitute for customers an aim in itself, but a means of better enjoying the principal service supplied. That is why it's significant that the statement of facts and issues says what it says. What the customer wants is the individual games. They might skip a few games and go to the bar. That just underlines that it's a knotty point, whether it's a session or individual. The tribunal in our case said, I won't invite your lordship to open it again, but at 118, paragraph 303, page 303, it simply moves to the question of valuation without further ado in terms of supplies. So, my lords, that's the reason why this is not a Section 80 case. This is an apportionment. And if I can turn now with my Lord Legate's comment in mind about the possible absurdity of a taxpayer saying, well, I relied on the guidance, and then I got more guidance, and I'd like to rely on that, please. It is central to our case that there is no juridical difference between the first wave of guidance and the second wave of guidance. Just as we say, if one counts back 4 years from the date when the payment was made, there is no juridical difference between the year -4, the installment which my clients did receive, and the year -5, which they have not received. They cannot be Section 80 payments for the reasons that I've just outlined. Let me leave Section 80 behind and turn to the reply to my learned friend's point about the status of the business. And our case is a very simple one. we don't suggest, of course, that the business briefs law, one, that they don't. Secondly, we don't, and I don't think the commissioners suggest that there's anything unlawful about the business brief. In other words, neither the first wave nor the second wave proposed any basis for this apportionment wasn't lawful. And in terms of the way that the commissioners administer it, apportionment is an area where very properly the commissioners do intervene and do give guidance to taxpayers on a very large scale. Just being abstract for a moment, it's no accident that the Victoria and Albert case is indeed a case about apportionment. And my learned friends, the Crown in its case mentions the V&A case and does so at paragraph 8.5 at page 186. And we of the bundle, and as I think I have already mentioned this morning, this reply, at 8.7, the Crown says, and we respectfully agree, I'm looking at page 187, 8.7, there may be more than one acceptable method of apportionment, and that's consistent with the party's position. So that's the Crown's position, having quoted in extenso from V&A on the previous page, and that's our position. So what has happened here is that we are, as the Crown suggests, in a V&A type situation, in which what has happened is the Crown has set out a safe harbour. Well-known concept, particularly in the tax world, where the state says, look, we're not giving you any orders, but if you do this, we, the state, tell you you will be in a safe harbour. We will accept your conduct. And that, in my submission, is all that's the only distance, as it were, that we need to go to engage with the business briefs as having legal significance. If I can just dip briefly into the...
Can I... first of all, Lord Hodge has a question for you.
Thank you. I wonder if it's correct that is as far as you can go. I mean, it is with the business brief. It is one thing. It is one thing for HMRC to have power to clarify matters that aren't clarified and give a safe haven. And I fully recognise that the revenue have power to enter into agreements to compromise cases. But where I still struggle with your proposition is the idea that the revenue have power, having lawfully collected a tax on a basis which, on your hypothesis, was perfectly lawful, they can then offer to repay the tax sorry, I'm having regard to the idea that one cannot untax by concession. Is there any authority that you can give me which suggests that the revenue, having lawfully received taxation, can then offer to pay it back?
My lord, there is no case which addresses that question, as far as I am aware, in the context of guidance as to a situation where there are multiple right answers. There's case law, obviously, on the question of concessions, but we're not in that sphere. There are many cases which deal with apportionment where there are multiple, I say right answers, I should say acceptable answers, But, my Lord, I'm not aware of an authority which addresses the very point that my Lord puts to me. What we believe on the taxpayer side it is that this may be the first apportionment case, certainly VAT, that has come before either this court or the House of Lords. And therefore,
what is the rationale, unless there is an error, what is the rationale behind the revenue offering to repay something that has been legally paid?
well, I've indicated that we are in the world of taxpayer revenue agreements. It is a self-assessed tax, and it is, in my submission, perfectly lawful for the revenue to point out that there are other lawful ways in which the calculation could be made, and to invite, as was done here, correction or adjustment. And of course, if there was nothing to correct, you have our submissions on Section 80, and say no more about that, then adjustment is the only place to go. And the case at this point does become one of great importance, because there are many apportionment methods out there, which is readily know. Input tax obviously is a major one. Business, non-business apportionment, retail schemes. I go into all of those details. Most of them are input, some of them, like retail schemes, are output. And we ask your lordships to endorse what the Court of Appeals said, both in V and A, and we've seen what the commissioners say, and we ask your lordships, we side with the commissioners, again, perhaps another irony, in terms of what they say at 8.7. It may help me answer my Lord Hodges' question to do as I was about to do, which is just to open these two cases. But I'm conscious there was possibly another question. But if not, may I invite...
I was going to just ask you to go back to page 446.
446.
Yes. It's the notice.
Yes.
And you'll see 3.2 poses the question, should I calculate VAT on a game-by-game or on a session basis? And it tells us that when players pay to participate in all or part of a bingo session, the supply you make to them is the right to participate in a number of games during that session for which you have received payment. As the players can't participate in further sessions unless they make further payment, the supply to the players is completed when the session ends. So the supply is the supply of the right to participate in the entire session. In these circumstances, we're told you should calculate the amount of VAT due on participation of session charges on a session-by-session basis. So that's a clear direction. The next paragraph distinguishes the situation when players pay to take part in an additional game, a flyer, that does not form part of the session charge. This is a separate supply of a right to participate in that further game. And so the VAT due on fees charged in additional games should be calculated on a game-by-game basis. So that seems pretty clear. It's not suggesting that either method is equally appropriate across the board. It's specifying a method of calculation which reflects the nature of the supply that's been made. Is it not?
My Lord, I fully understand the point that my Lord has put to me. It's pretty clear, and it is. but the position of the Crown is that it's a mere expression of opinion. We don't respectfully concur with that, but the Crown rightly says that it has no power to give any direction. My Lord, you use the word direction, but Crown, we respectfully agree, has no such power to direct.
Well, I think equally, one could equally call it advice, but it's expressing the Commissioner's understanding of what the legal requirement is.
My
And
Lord,
a should is not a moral should; it's a legal should.
it is well, as my learned friend says, the 2007 document that offered the chance to recalculate as you may, but I understand completely, if I may say so again, what my Lord is putting to you. But if one is operating a bingo hall where the prizes are even all the way through the session, this won't be of any interest.
Well, no, because I mean, then it's like paying for a season ticket to Covent Garden or for that matter, White Hart Lane. It doesn't matter whether you break down performance or game by game or look at the season as a whole. It does matter, however, in relation to bingo because of the fact that one game can subsidize the prizes for another game.
Which is, of course, an internal matter, but the reason that we are troubling the court, I accept. But my Lord, the position is one just has to follow I suppose, the logic of the various possibilities. True. Commissioners say no, mere expression of opinion, perhaps advice would come to the same thing. We certainly don't and have never said force of law. We have said requirement, but we place our case, I won't repeat myself, in this context of apportionments, more than one acceptable answer, and the advice that my Lord puts to me, or that the Commissioners put out in paragraph 33.2, is that they see an additional and indeed preferable, and certainly financially preferable to the taxpayer, point on the spectrum, and that is session. And naturally, my clients were delighted and agreed to that. And then the Commissioners said, and you can go back. My clients were also delighted, and we're here. And that and the analysis, as I said, both series of notices, whatever status my Lord's assigned to them, it's got to be the same. I mean, they're couched in a similar style, as all these notices are. But looking at 452, and there's the heading there, making claims or adjustments, made my point now. If it's not Section 80, if the game basis was not unlawful, leading to the payment of tax that was not due, then what we have here is an invitation to make a Regulation 38 adjustment. And I've said, of course, that the authors in this 2007 document thought that Regulation 38 had a time limit, was later repealed, having already been held to be unlawful. So, if I may say so, my Lord, everything turns on your Lordship's perception of this process of clarifying and indeed entering the safe harbor in an area of tax practice where multiple answers are possible, particularly with apportionment. And my Lords, if I can just very quickly build on the references that the Crown have made to the Victoria and Albert case, just very briefly, because you also will have seen text. The case itself is at 37 at 859, tab 37, page 859, and the Crown very helpfully cited the part of the judgment at 1023, letter H. That's page 866 of the bundle. To 1024, the parties are, I think, agreed, and looking at 1024, the court says that what error was under the then regulation, and then at B, if they had been compelled to make their return on this basis, when in law they couldn't be so compelled, there would be a convincing argument to the effect that the trustees had made an error. All that has in fact happened is that the trustees, having sought independent advice, been able to devise a basis for their returns which produces a more favourable result. And then his lordship quotes the tribunal and says no error at the be made. As it happens, it is the commissioners in this case who have devised a process which offers a more favourable result and have very properly offered taxpayers the opportunity to do it a different way, but a way which was no less legal. And in my submission, that perhaps is an answer to my Lord Hodges' concern. Nothing has been taken, if I may just finish this, nothing's been taken out of the consolidated fund which didn't have parliamentary consent. Give me, my Lord.
Sorry, just on the V&A case, I'm looking at page 866, foot of the page. Can you just help me? What is the Appendix J that's being referred to there? Is that some subordinate legislation?
My Lord, I was just going to take your lordships to that very thing. It's at page 864.
And is it legislation?
It's a retail scheme, which is so Appendix J, as your lordships can see, I won't read it, is one of a number of, I'm almost inclined to say products, options. None of them are compulsory, entirely voluntary system, which the commissioners have for many years offered the retail sector to apportion their output tax. As you can see at the bottom, it's just got a few bullet points. And then at letter J on page 1021 of the report, 864 of the bundle, there is no special method of apportionment, but your calculations must be fair. You must be able to justify them. Here's an example of how you can apportion that based on your income. And then at the top of the next page, remember, you don't have to use this method. If it isn't suitable, you can use any other formula, but it must produce a fair result. You must have the prior agreement of your local. So it's structured slightly different, but in substance, here's a safe harbor. Actually, this is one you just need to check with your VAT office. And Ms. Justice Turner, and the case obviously went no further, effectively endorsed one of the absolute pillars of VAT administration, which is when a taxpayer is offered a, quote, deal or a procedure by the commissioners and takes it up, then both parties are bound by it until either party resiles going forward. There is nothing to stop the parties agreeing to resile with retrospective effect. That's our case. But this is one of the reasons why I mentioned that this, as far as we know, is the first case that which such matters of apportionment have been before the Supreme Court or its predecessor. And it is therefore a topic of great importance. I don't know what underground streams there are. There was some perhaps gentle inquiry made of my learned friend yesterday, other considerations, which commissioners very properly always have. We note that there's something to do with the telecoms industry, which the commissioners mentioned in the background. Obviously, it's not a gambling point, but this is a point of great importance. I've now made that point in reply sufficiently, I hope. Can I simply mention the GUS?
This is a rather, I mean, this is discussing a rather different type of apportionment. We're all familiar with the situation where somebody may purchase something which is partly used for business purposes and partly used for personal purposes, and it's necessary to make an apportionment, and in the very nature of the thing, it can't be calculated with mathematical precision. You have to just arrive at a fair assessment. There's an evaluation involved. The business brief we were looking at earlier was talking about a different type of apportionment, which is where you have an amount of money paid, only a part of which is the taxable consideration, and you have to try and you have to arrive at what that figure is by, in the context of bingo, by deducting the amount of the payment which is used as a stake for the prizes. And in principle, that's a matter which is capable of being calculated precisely. Lord Sales.
Yes, I wanted to make, what I think is a related point, that one looks at page 866 in the V&A case at the foot of the page. The court is very specifically making the point that Appendix J is permissive in terms of what the revenue will accept, whereas our notice isn't permissive. We've looked at it. It's saying what the revenue understands to be the correct way of calculating the turnover in this particular situation. What do you say about that?
My lord, I can fully understand that last point, my Lord Sales point. If I may just deal with that, it does use language "you must," "you should," and the commissioners obviously say not forcible. So what I say about that is, notwithstanding the rather emphatic language, it does not have the effect of a direction. It is a safe harbor offer, generically similar to that which the input tax point that's made in the V&A case. And turning, if I may, to my Lord Reed's intervention, my Lord, of course I accept that input tax apportionment is looking at a radically different thing, but there is a wealth of guidance, huge number of cases on the question of input tax apportionment. If I'm right on the Section 80 points, then we are certainly on the acceptable spectrum here, and we've all got almost no guidance in the cases. So the only level of generality perhaps that matters is that it's an apportionment. Commissioners have indicated what is acceptable. They've done so, as my Lord Sales puts to me, in rather emphatic terms, without any legal obligation accruing. But we say, once made the point that both series of public notices of equal juridical standing, once we go along with them, they bind us and they bind the commissioners. And I suspect that ultimately this doesn't matter, would not be an attractive outcome for commissioners, that such notices as these are either construed on one end of the spectrum as requiring taxpayers to do things as a matter of legal entitlement on the part of the commissioners, which they don't claim, or at the other end, we respectfully reject, invite your lordship to reject, a mere passing expressions of opinion. My lords, may I quickly show your lordships the GUS case, which is a very short companion to the V&A case. That's at divider 53 at page 1237. Divider 53, page 1237. And this is an output tax case. V&A was input tax. Obviously, museums are partly exempt. They have input. Gus merchantising This is a Court of Appeal case. It adopted a methodology for dividing up its daily takings. One of the classic problems in supermarkets is the zero-rated food and the standard-rated drink and so forth. So there are many such deals done. There was an off-the-shelf product, as it were, from the commissioners, and a debate as to whether effectively safe harbour arrangement, as I would describe it, was bespoke or off the shelf. If one looks at paragraph page 1239 at H, this is Lord Justice Steyn, as he then was, just below H, the learned Lord Justice says, in orally opening appeals, Mr. Goy QC initially approached the matter in a way, it seems to us, ultimately Mr. Goy on behalf of that apart from their specific statutory power under Reg 2 of the VAT supplies by retailers to adapt by agreement with a retailer any retail scheme, the commissioners have under their general power, care and management, authority to conclude a binding freestanding agreement as envisaged in issue 2. So the purpose of the citation is simply to point out, the Court of Appeal at least have said, commissioners have got the power to reach a consensus and agreement with the taxpayers how its affairs should be operated. I don't put it any higher than that. Retail schemes that are mentioned are another set of off-the-shelf products. They're very formal. So at a different level from the business brief here, but the effect is to apportion output tax. And the important point is that the power is there. And in our submission, a taxpayer, a self-assessing taxpayer looking at this, even if perhaps he or she might understand that he or she is being given a direction of legally binding force, which parties are agreed is not the case, would certainly, they wouldn't analyze it in terms of contract or agreement, as these cases indicate, should be the case. The taxpayer would certainly be entitled to conclude that, number one, the game approach was lawful, number two, the session approach is lawful, and that the invitation to correct or to adjust lawful and capable of acceptance. My Lord.
Mr. Cordara, even on your own case, the offer made was an offer to go back 3 years, wasn't it? You seek to get round that by saying that that was made on a basis that there was a time limit for adjustments, and it's now held there isn't. But that doesn't convert the offer made into a different offer that wasn't. You could only rely on the law about time limits, couldn't you, if your clients had some independent legal entitlement to go back more than 3 years. But as on your case they don't, and it all hangs on the offer, you can't base a legal right on a hypothetical offer that they would have made if they'd had a different understanding of the law. So even at that point, it seems to me, you have a big problem.
My Lord, the tribunal had held in 2003 that the later abolished Regulation 1 capital A was unlawful. So the level of knowledge, there are really only two possible levels of knowledge dealing with my Lord Legate's point. One is just to look ex facie the offer, which your lordships have looked at several times, which, as I've said, indicates claims or adjustments going back, and does not ex facie put any particular time limit on it. And therefore,
it does when you cross-refer. I think you accept that it does contain an a reference time limit.
My lord, I do accept that, but if you cross-refer is the key, if I may say so, my lord's question. One either assumes no legal knowledge or all the legal knowledge that was available at the time. And that includes the decision, which, once again, having difficulty finding, it's one of the GMAT cases, I will find it, of Sir Stephen Oliver, to the effect that the 3-year time bar was unlawful.
But
So,
that doesn't convert it into a different offer.
well, with respect, it does. It's either an offer made in the context of the correct, it's either an offer made in the correct legal context, in which case the well-informed taxpayer would know that there was no time limit. The GMAT case to which I refer and the reference to which I will find, or it's just dealt with on the face of the document, and there is no time limit once it digs into the process, gets on with it. But my lords, that's why we say there's no juridical difference between year 4 and year 5 backwards in time. Even taking, if I may say so with great respect, taking my Lord Lager's point, one still has to, and I'm mindful of my Lord Hodges' concerns about what's going on here. Do the commissioners have power at all to do this? My submission, they do, reasons I've given. As I say, juridically, there is no difference between year 4 and year 5. Mindful of my Lord Lager's challenge, if I may put it that way, the context, of course, is, or the matrix, if one is going to look at this as a commercial contract, which it isn't, would naturally include the correct legal background in my submission. Otherwise, there would be stake. It isn't, and it ought to be infused in any event, since this is the state with whom one is reaching consensus. It must be right that the state is to be taken as making its offer on the basis of the law, as it had by that date judicially been
So
held.
the reasonable reader, is this right, would read the offer when it says that there is a time limit of 3 years on adjustments as meaning there is no time limit on adjustments?
Well, the offer leaves matters entirely at large as to specific time limits.
No, because it says it refers you to the notice that sets out the how you make your claim, and that has the time limits in it.
Indeed, but the reasonable reader, or perhaps the accountant advising the reasonable reader, which is a more likely scenario, would say, but that has been falsified. The law should be taken from the first-tier tribunal on that point rather than the notice. Hypothetical discussion. So, my lords, that is that deals with a large part of the ground that I needed to cover in response to my learned friend's points. My lords, I'm conscious we haven't necessarily had the break, and I wonder if this is a convenient moment. If not, no problem.
Well, we can certainly have a 5-minute adjournment, and we'll give you an opportunity to consider whether there's anything you need to add.
Indeed, and perhaps to find a reference.
Yes, very well. Well, in that case, we'll close down our video and audio feeds for about 5 minutes. Welcome back to the Supreme Court, where we're hearing the appeal of KE Entertainments and Her Majesty's Revenue and Customs. And we're currently hearing the closing submissions on behalf of the taxpayer, given by Mr. Roderick Cordara, Queen's Counsel. Mr. Cordara.
My lord, I'm grateful. May I, on this question of the Regulation 38(1)(a) point, may I invite the court to look at divider 61, page 1421, divider 61, page 1421 of the bundle, there is a decision of Stephen Oliver, sitting in the VAT Tribunal in 2002, reported in 2003, which covered a variety of questions. Facts are not relevant, including, if one looks at page 1420, just at the brief rubrics, the third one, community law, consideration, decreasing consideration, adjustment through that accounts, 3-year limitation period. So this is what the well-informed taxpayer would know about. If one then turns to paragraph 60 at page 1439, paragraph 60, page 1439, the learned judge refers to the now abolished regulation 1A, and he over the page refers at para 64 to the underlying European diaries, which is article 11C1, and he read that he refers to Goldsmith's German case. And then he says at 65, here the condition imposed by Rule 38(1)A is concerned neither with the procedures for making it nor with the evidence required to support it. Properly understood, the 3-year cap as imposed by Rule 38(1)A is not a condition at all. It is a blanket limitation which has the effect of ousting the taxable person's basic right to be taxed on the consideration received by him and no more. As such, the 3-year limitation on the making of the claim by reference to the time when the original supply was made is incompatible with Article 11 generally and with DMAX right under Article 11C1 in particular. Rule 31A has rendered ineffective DMAX right to leave. On that basis, therefore, we think DMAX is entitled to rely on its community law right. And the extent that the Commission's decision seeks to deny DMAX those rights is wrong. So that is what we say is the correct position, was the correct position, notwithstanding that it would appear that Notice 700/45 had not been amended by 2007. Your Lordships now really do have my submissions on that point. I'll move on to the final phase, if that's convenient, which is to address in response quite briefly the issue of Article 19, Regulation 38. We've set this out to an extent so in our case from particularly paragraphs 63 to 69, starting on page 129 of the bundle, which is obviously seen. Second point, as we know from, I think it was the Pendragon case, the function on such an appeal as this is to decide whether the upper tribunal got it right or not. That's the observation of Lord Carnworth in that case at the end of the decision. And we say very simply that Lord Eric decided, with great respect to Lordship, decided matters properly. We've set out why we say his decision was right on this Article 90 Regulation 38 question. We set that out at paras 44 to 48 of our case. I will not make reference, that's at page 122. My learned friend cited 3 or 4 cases which perhaps merit a brief response. The Goldsmith's case, which I don't ask your Lordships to open, it's at tab 33, page 780. We've dealt with it at para 59 of our case. That case, as with Freeman's and indeed Grattan, were all cases where at the original Article 73 stage, there was what Lord Walker would have described as an overt contractual agreement. And therefore one got into the Article 73, Article 90 system on the basis of overt agreement, actual payments, and that is, of course, different from our case, where one doesn't have that, one has this deeming. And we say none of these cases are sister court because, of course, they say if you've got into the system, as it were, by an original transaction which had an observable commercial reality about it, we the judges, want to see some observable commercial changes to reality before you can have your money. And that's the theme, really, certainly in Goldsmiths and Freeman's and inventive tax solutions. And that's comparing apples with apples. Your Lordship obviously have my point that in our case, we should compare pairs with pairs in the sense that we go in with a deeming and that deeming is then changed along the lines that your Lordship's aware of. The Freeman's case, again, that's at tab 36, page 844. What we say about that case can be found at para 60 of our case. Without asking your Lordships to open it, we would observe that at para 33 of that case, the European Court makes the point that Article 11C1 or Article 90 does not require any contractual change to occur. So even in an overt commercial situation, contractual changes don't occur. But in any event, to place that sort of obstacle in the way of the taxpayer accessing any rights it may have under Article 90 would be unacceptable. We submit to European law. The Gratin case is not covered in our case. It is, I'll deal with it very shortly, but unfortunately I do have to invite the court just to open it. It's at tab 42, page 967. And I can deal with it quite shortly. In this case, the taxpayer was trying to reduce its turnover on sales, essentially by A to B, by reference to commission payable to B. So bilateral situation and a case which under the later directives might well have gone the other way. The critical point in the case is found if one looks at page 984 and following. That is to say, paragraphs 23 and following of the judgment on page 518 of the report. And at para 23, as your Lordships see, my learned friend pointed out, it's a case concerning the second directive. Second directive came out at the same time as the first directive. So it was quite literally the very first nuts and bolts type directive telling the member states how they were to begin the process of harmonizing their turnover tax. And it was very much a first attempt, which was then vastly improved and fleshed out a decade or so later by the sixth directive. And all that is being said in this case between 23 and para 34 is that the second directive simply didn't make provision for the kind of revisitation that the sixth directive and the principal directive now make. If one looks at 32 and 33, the judgments at 32 says the court should also examine Grattan's argument that any attempt to distinguish the position before and after the 1st of January 1978 is misconceived because that distinction fails to take into account the continuity of the VAT system. Pausing there, what Grattan unsuccessfully were trying to do was to say, well, The sixth directive, which came out on or into force on the 1st of January 1978, was simply continuing a broad brush solution, which was already in place when inter alia it introduced Article 11C. And the court replies at 33 saying, in that regard, as the Advocate General has stated in point 49 to 50 of her opinion, the degree of harmonization under the second and sixth directive isn't comparable. And I won't read on, but a specific way in which it was not comparable was that if one turns the page to 36, there was no Article 11C. And my learned friend put placidly, my learned friend made no secret of this, and I think that citing it to indicate that Article 73 could not of itself allow revisitation. But real point of the case, and the reason it is not helpful, because it's simply not even an Article 11C case. My Lords, unless I can assist your Lordships in any other way, those are our submissions in report.
Thank you very much indeed, Mr. Codara. We're most grateful to both you and Mr. Thompson, and also Ms. Roxburgh for her role in this, for the very helpful submissions we've received. This is a knotty problem that's troubled courts and tribunals for quite some time, and we'll now put our thinking caps on and try to come up with a satisfactory answer. The court will now adjourn.